Hey guys, welcome back to our new video. I am teaching you the Customs Act 1962. In the chapter number 5, we have seen till time the 16 sections. In the same, we have seen from section number 12 to section number 26A. So we are once again repeating the section number 12 to section number 26A. Section number 12 is dutiable goods. Section number 13 is duty on pilfered goods. Section number 14 is valuation of goods. Section number 15 is determination of rate of duty and tariff valuation of imported goods. Section number 16 is date for determination of rate of duty and tariff valuation of exported goods. Section 17 is valuation. Section 17 is assessment of duty. Section 18 is provisional assessment of duty. Section 19 is determination of duty where goods consist of articles liable to different rates of duty. Section number 20 is re-importation of goods. Section number 21 is goods derelict, break, etc. Section number 22 is abatement of duty on damaged or deteriorated goods. Section number 23 is remission of duty on lost, destroyed or abandoned of goods. Section number 24 is power to make rules for denaturing or mutilation of goods. Section number 25 is power to grant exemption from duty. Section number 26, 25A, inward processing of goods. Section number 25B, outward processing of goods. Section number 26 is refund of export duty in certain cases, and section number 26A is refund of import duty in certain cases. So these all sections I have already explained to you in my previous videos. If you want to watch these videos, please visit to my channel and please watch the same videos. Now in this video we are going to see section number 27, claim for refund of duty. So we are going to see the here section number 27. Section number 27, claim for refund of duty. Subsection 1, any person claiming a refund of any duty or interest. Clause first, paid by him. Clause B, borne by him, may make an application in such form and manner as may be prescribed for such refund to the Assistant Commissioner of Customs or Deputy Commissioner of Customs before the expiry of 1 year from the date of payment of such duty or interest. So if any person want to take a refund of duty, he have to do the application to the Assistant Commissioner of Customs or Deputy Commissioner of Customs within 1 year from such date. Provided that where an application for refund has been made before the date on which the Finance Bill 2011 receives the assent of the President, such application shall be deemed to have been made under subsection 1 as is stood before the date on which the Finance Bill 2011 receives the assent of the President, and the same shall be dealt with in accordance with the provisions of subsection 2. Provided further that the limitation of 1 year shall not apply to where any duty or interest has been paid under protest. So if the importer or exporter has paid the duty or interest under protest, so limitation of 1 year will not applicable. So this is very important point in the section number 27. if importer or exporter paid the duty or interest under protest, the claim for refund period of 1 year is not applicable for the duty paid or interest paid under protest. Provided also that where the amount of refund claimed is less than rupees 100, the same shall not be refunded. So, if the claim for refund amount is rupees 100 or less than 100, the same shall not be refunded to the importer or exporter. Explanation: for the purposes of this subsection, the date of payment of duty or interest in relation to a person other than the importer shall be construed as the date of purchase of goods by such person. Subsection 1A. The application under subsection 1 shall be accompanied by such documentary or other evidence, including the documents referred to in section 28C, as the applicant may furnish to establish that the amount of duty or interest in relation to which such refund is claimed was collected from or paid by him, and the incidence of such duty or interest has not been passed on by him to any other person. Subsection 1B. Save as otherwise provided in this section, the period of limitation of 1 year shall be computed in the following manner, namely. So, in the subsection 1B, the period of limitation of 1 year shall be computed as per the following manner. Clause A. In the case of goods which are exempted from payment of duty by special order issued under subsection 2 of section 25, the limitation of 1 year shall be computed from the date of issue of such order. If any goods are exempt from payment of duty under subsection 2 of section 25, the limitation of 1 year from the refund of such duty is start from the such notification or order date. Clause B. Where the duty becomes refundable as a consequence of any judgment, decree, order or direction of the appellate authority, appellate tribunal or any court, the limitation of 1 year shall be computed from the date of such judgment, decree, order or direction. So, if any duty becomes refundable as a consequence of any judgment, decree, order of any appellate tribunal, appellate authority or court, the date of such order, decree or notification should be considered for the refund of such duty. Clause C. Where any duty is paid provisionally under section 18, where under section 18, if any duty is provisionally paid, the limitation of 1 year shall be computed from the date of adjustment of duty after the final assessment thereof, or in case of reassessment, from the date of such reassessment. So, in the clause C, where any such duty is paid provisionally under section 18 of the Customs Act 1962, the date for limitation of 1 year shall be computed from the date of final assessment of such duty or reassessment or from the date of reassessment. Subsection 2. If on receipt of any such application, the Assistant Commissioner of Customs or Deputy Commissioner of Customs is satisfied that the whole or any part of the duty and interest, if any, paid on such duty paid by the applicant is refundable, he may make an order accordingly, and the amount so determined shall be credited to the fund. So, in the subsection 2, if on receipt of any such application, the Assistant Commissioner of Customs or Deputy Commissioner of Customs is satisfied that the whole or any part of the duty or an interest, if any, paid on such duty paid by the applicant is refundable, he may make an order accordingly, and the amount so determined shall be credited to the fund, provided that the amount of duty and interest, if any, paid on such duty as determined by the Assistant Commissioner of Customs or Deputy Commissioner of Customs under the foregoing provisions of these subsections shall, instead of being credited to the fund, be paid to the applicant if such amount is relatable to Clause A. The duty and interest, if any, paid on such duty paid by the importer or paid by the exporter, as the case may be, if he had not passed on the incidence of such duty and interest, if any, paid on such duty to any other person. Clause B. The duty and interest, if any, paid on such duty on imports made by an individual for his personal use. Clause B. The duty and interest, if any, paid on such duty on imports made by an individual for his personal use. Clause C. The duty and interest, if any, paid on such duty borne by the buyer, if he had not passed on the incidence of such duty and interest, if any, paid on such duty to any other person. Clause D. The export duty as specified in section 26. Clause E. Drawback of duty payable under section 74 and 75. Clause F. The duty and interest, if any, paid on such duty borne by any other such class of applicants as the central government may by notification in the official gazette specify. Clause G. The duty paid in excess by the importer before the order permitting clearance of goods for home consumption is made, where subclause first, such excess payment of duty is evident from the bill of entry in the case of self-assessed bill of entry. Subclause second, the duty actually payable is reflected in the reassessed bill of entry in the case of reassessment. Provided further that no notification under clause F for the first provision shall be issued unless, in the opinion of the central government, the incidence of duty and interest, if any, paid on such duty has not been passed on by the person concerned to any other person. Subsection 3 of section 27, claim for refund of duty, states that notwithstanding anything to the contrary contained in any judgment, decree, order or direction of the appellate tribunal, appellate authority or any court in any other provisions of this act or the regulations made thereunder or any other law for the time being in force, no refund shall be made except as provided in subsection 2. Subsection 4. Every notification under clause F of the first provision to subsection 2 shall be laid before each house of parliament if it is sitting as soon as maybe after the issue of the notification, and if it is not sitting within 7 days of its reassembly, and the central government shall seek the approval of Parliament to the notification by resolution moved within a period of 15 days beginning with the day on which the notification is so laid before the House of People, and if Parliament makes any modification in the notification or directs that notification should cease to have effect, the notification shall thereafter have effect only in such modified form or be of no effect, as the case may be, but without prejudice to the validity of anything previously done thereunder. Subsection 5. For the removal of doubts, it is hereby declared that any notification issued under clause F of the first provision to subsection 2, including any such notification approved or modified under subsection 4, may be rescinded by central government at any time by notification in the official gazette. So section number 27 is of claim for refund of duty. In this subsection 1, we have seen any person claim for refund if the duty or interest paid by him or borne by him. The refund of applicable should be done within 1 year from the date of payment of duty or interest, and if the duty or interest paid under protest, the 1 year period will not be applicable. The importer or exporter can make application for refund after 1 year also. In this subsection first A, the application shall be accompanied by such documentary and other evidence including the documents referred in section 28C. And in this subsection first B, when the 1 year period applicable is mentioned, if there is any high court or appellate authority, appellate tribunal, any order, decree or decision, from that date the 1 year will be counted. Also, if under section 25 subsection 2, if any order or notification comes from that date of order or notification, the 1 year will be counted. In this subsection 2, the Assistant Commissioner of Customs or Deputy Commissioner of Customs can refund the duty amount. In subsection 3, in subsection 3, if any court or appellate tribunal or appellate authority has given order to not the under subsection 2, the refund will be not granted. In the subsection 4, every notification issued under clause F of first provision to subsection 2 shall be laid before Parliament, and it should be passed in the Parliament. If Parliament has hold the notification or given instruction to modify the same should be modified, and then it should be published. And in the subsection 5, central government can rescind the notification issued under subsection 2 of first provision of subsection 2. Central government can rescind the said notification or order. So in this section 27, we have 7 these subsection 5. I will explain about the refund, claim for refund of duty. So there is 3 main points in this section is for claim for refund, you have to do application within 1 year, and if any duty or interest paid under protest, the 1 year period will not be applicable. And under subsection 2, the Assistant Commissioner of Customs or Deputy Commissioner of Customs can refund the amount to the fund. So who is the proper officer for giving refund? Is Assistant Commissioner of Customs or Deputy Commissioner of Customs. This question may be arrived in your MCQ multiple choice questions exam. Also there is possibility to come question on the duty or interest paid under protest. And what is the period of claim for refund of duty is 1 year. This also come. So these 2-3 points are very important, and you have to keep this in your mind and don't forget about it. So guys, we have seen up to section number 27 in the chapter number 5 of Customs Act 1962. So guys, I am once again repeating the sections which we have already seen in the chapter number 5. Section number 12 is of dutiable goods. Section number 13 is of duty on pilfered goods. Section number 14 of valuation of goods. Section number 15, date for determination of rate of duty and tariff valuation of imported goods. And section 16 is of date for determination of rate of duty and tariff valuation of exported goods. Section number 17 is of assessment of duty. Section number 18 is of provisional assessment of duty. Section number 19 is determination of duty, where goods consist of articles liable to different rates of duty. Section number 20 is reimportation of goods. Section number 21 is goods derelict, wreck, etc. Section number 22 is abatement of duty on damaged or deteriorated goods. Section number 23 is limitation of duty on lost, destroyed or abandoned of goods. Section number 24 is power to make rules for denaturing or mutilation of goods. Section number 25 is power to grant exemption from duty. Section number 25A, inward processing of goods. Section number 25B, outward processing of goods. Section number 26 is refund of export duty in certain cases. Section number 26A is refund of import duty in certain cases. And in this video we have seen section number 27, claim for refund of duty. So these are all sections we have seen till time. If you like this video, please like, share and subscribe to my channel, and expand your knowledge about the Customs Act 1962, customs clearance, import export. I am giving you free knowledge. If you are a working professional, you are not able to read books on daily basis. So this video makes for you. You can watch videos anytime, anywhere, while traveling, while driving. You can also listen these videos. Not watch while driving, but you can listen videos while driving. If you are a working professional, you spend a lot of time in the traveling on daily basis. On that time you can watch these videos and expand your knowledge about the Customs Act 1962. Thank you guys. We will meet again in the next video with another sections.